Well, good afternoon, everyone. And this is our last panel of the day. And I, I will dare making many promises about this panel, but not yet. Before doing that, of course, the uh, the title of the panel has a ring of its own. In and I have only the task to present the moderator, my former colleague Mallory Silberman, um, and very very faithful to the request of 40 words. Mallory is among the world's most experienced young practitioners of investment arbitration, having represented investors and 17 states in 50 cases. She's a former Arnold Porter partner, and her consultancy, Mallory Silberman, or Miss Arbitration, now provides bespoke advocacy training and helps sovereigns with capacity building. When I said that I can promise many things about this panel, not because I had anything to do in the making of it, but because I know that whenever Mallory, takes the task of embracing any project, there are many things that those projects will have. They will have some definitely creativity, visual creativity, colors, and some and certain way of explaining things in such a way that you will feel as if we're in a game, and the end of the whole thing, I can also promise you that you will learn. So that reminds me, with some proportion, learning by playing, which is perhaps the best way of learning. So with that, really, this is one of the panels that everyone has been expecting. And Mallory, you have the floor.
Thank you so much, Jose Antonio, and thank you all so much for coming out today. Before we begin, I wanted to give a word of thanks to Jose Antonio, to Ian, to the rest of the WOW team for putting together such a fantastic week of programming for us all. I also wanted to make sure to thank a few of the people who have been running around behind the scenes, literally, to make sure that everything goes smoothly this week. And to point in particular to Maria Matamala and to Momin Musin, who yesterday, literally while they were running from one venue to the next, somehow managed to simultaneously hold an umbrella and host a video practice call or test run for this session today. So bravo to you. Thank you so much. I hope you get some sleep soon. And thank you also to Laura Thompson and James O'Neill for taking such great care of us here at Baker Botts. So, FYI, the millennials are coming. Raise your hand if you are not entirely sure what that means. And I should say, it's okay, I came up with the title and I promise I won't be offended. You can raise your hands. Well, I'm not really sure that we can predict the future, but as moderator, I have been thinking about this session a lot. And I think that there are about 10 things that I can say right now. And I figured I would begin with a rundown or a listicle of sorts. So first of all, the millennials are coming. And second, that's our topic for today. We have some fabulous panelists lined up for you, both here in the room and appearing virtually on the screen. And I will introduce them all properly very soon. But first, we need to get through some preliminaries. Now, third, what am I up to? Those preliminaries are going to take a little bit longer than usual. I'm going to speak for a few minutes before I hand over the floor, because what we want to do today is to talk with you and not just talk at you. And fourth, in order to do that, we're going to have to explain some logistics and go through some background. So fifth, on the subject of logistics, if they're not already in your hands, please take out your phones. Go quick, the millennials are coming. Get your phones, get your phones. And that goes for everyone who's participating on Zoom as well. You're going to want to have your phone for this session. So sixth, if you are attending in person and you didn't pick up one of the little card packets, please make sure that you do so. The members of the WOW team will be walking around the room with the little basket. You're going to need those as well. Now, seventh, and turning quickly to some background, in theory, it should be easy to draw dividing lines between generations. But in practice, it's especially tricky to do it in the field of international arbitration. For example, we can't simply assume that people joined the field X number of years after birth, because we come from different places which have different systems of legal training, for example. And there are so many different flavors of international arbitration, so many different career paths to follow, and all of that just contributes to making this process a bit tricky. And moreover, in order to complicate matters, I have learned that the internet apparently disagrees on precisely which birth years correspond to which generations. And I say all of that in the hopes that no one's going to cancel me when I say this. But basically, we millennials are the generation that was born between the early 1980s and the mid 1990s. And to spare you from the math, that means that most of us currently are in our 30s/early 40s. For a while, we were the new kids on the block. And incidentally, I don't think I have ever said that phrase in a professional context. I'm glad that you laughed. I was worried that no one would get it. But for the members of Gen Z who may not know, there was a boy band that actually preceded the millennials' time. If you don't know the boy band by that name, you can ask ChatGPT or a member of Gen X about it. But eighth, as this example itself illustrates, we millennials are no longer the youngest ones in the office. We're explaining 80s references to the newcomers, the members of Gen Z or the Zoomers who are starting to enter into the profession. And in parallel, we ourselves have been climbing up the arbitration equivalent of the corporate ladder. You're starting to see us in very senior positions alongside our friends in Gen X and the baby boom generation. You're seeing us, for example, in very senior positions. We're being retained as lead counsel. We're earning tenure, running practice groups, managing institutions, heading government units, leading organizations, and yes, sitting as arbitrators. And that's something that's different because 8th, 9th, whatever number I'm up to, we millennials are now starting to join the senior ranks of international arbitration. We're starting to become the most senior decision makers. And that's a really big change. So to take one example of why that's so, let's do a little experiment. Since you all have your phones out, I would ask that you use them to go to msarbitration.com/play. If you have the email from last night, this is the same link that we sent to you. And again, millennials, if it's easier, you can use this QR code. Scroll all the way toward the bottom of the page and you will see a part that says Slido. And that's the special conferencing software that we're going to be using to poll the audience today. Now, if you don't want to do this, you don't have to, of course, but I think it will be fun. So I'll just leave this up here a second. And then we're going to start by asking you 2 questions. Everyone ready? First question, where'd you grow up? And by the way, you can respond with the country or the city. The software should work either way. Oh, lots of Brazil. So the bigger the size of the text on the screen means that more and more people have responded with those words. If people are still typing, I'll give you a little bit longer. Not done growing yet, fair. Let's try another question. So not just where did you grow up, but what languages do you speak? One that has 5 responses from one person is very, very impressive. So as we're finishing up this experiment, I can move on to the point that I wanted to make, which is that in international arbitration, as I'm sure you already knew, and this illustrates anyway, our audiences don't just come from one place, and our audiences don't just speak one language. They come from many different places and tend to speak more than one native language or otherwise. And to me, that's one of the best aspects of our field. But it can also be the most frustrating, because writing or arguing or crafting any sort of messaging for that audience can be incredibly difficult. And historically, one of the ways that we dealt with this is essentially to use age as our common denominator. So we would draft messaging that was targeted or tailored to the baby boomer generation or to their predecessors. We would use turns of phrase and analogies and stories and points of reference that would resonate with that generation. But nowadays, things are changing. As I mentioned, we're starting to have other decision makers in the mix. And the question is what that means for our practice. You know, how are things going to change on the practical level? Will it impact our phrasing, the way that we work together? Just seem like something that's worth exploring. And even if we don't have all of the answers today, we just wanted to start the conversation. So while you won't figure out what the future holds by the end of this session, you will walk away with a sense of the people you might encounter, be arguing to, or working with. So let me just quickly get to the last point, and then I will introduce our wonderful panelists. And that last point is that some of you may be sitting there thinking that it is just such a millennial move to take my own generation and make an entire panel about it, when surely this happens all the time, right? Every 15 years, we have a new generation. But remember, the practice of international arbitration and the practice of that as a full-time career is a modern phenomenon that isn't something that has existed for so long. And since we're in Washington with ICSID just down the road, I'll use that as an example. So the ICSID convention was created around here-ish, which makes it barely any older than the members of Gen X. And the first 10 ICSID cases were conducted around here, making them barely older than the millennials. The very first BIT case that ICSID heard was around there. So you should know it is younger than Taylor Swift. This doesn't happen every day, friends, in our particular field, and that's why we're going to talk about it. So as mentioned, we have 4 wonderful panelists, and I'm going to stop talking very soon, but I need to introduce them first. And I'm very excited to do that because I have worked with, gotten to know, and taught some of these panelists over the years and learned a lot from them too. So first of all, we have Gaela Gehring Flores, who is based here in Washington and has almost 3 decades of experience in our field. She started out as a litigator and then very quickly became one of the leading practitioners in international arbitration. In addition to serving as counsel in more than 60 high-stakes matters, and also currently as the chair of international arbitration at Hughes, Hubbard & Reed, Gaela is potentially the first person who ever uttered the phrase international arbitration in my presence. And given the theme of our panel, I also should mention that she has a podcast, which is called The Tea on International Arbitration. Next, joining us over Zoom is Mairée Bidegain, who is a fantastic arbitration attorney currently based in Chile. Over the years, Mairée has been in private practice. She has been in public service. She has worked at an arbitral institution. She spent a long time here in Washington working as a team leader and senior legal counsel over at ICSID and teaching in parallel at 2 of our local law schools. And I also should note that during the ICSID rules amendments, Mairée was one of the voices that everyone listened to whenever she spoke up. She recently was appointed to the ICSID roster and is already sitting as arbitrator. Back here in the room, we have Dr. Kendra Magraw, a second-generation practitioner of international arbitration, and we actually went to middle school and high school together. So I'm very, very excited to get to say Dr. Kendra Magraw. We didn't know each other in middle or high school. I discovered that she did this, that she was in this area of practice when I picked up the ICSID review one year and recognized her name. And so as I mentioned, it's very, very fun to say Dr. Kendra Magraw. In addition to her PhD, she has a JD, 2 master's degrees. She has worked at ICSID, the ICJ, the Court of Arbitration for Sport. She's currently at WIPO, and in the process of earning her doctorate, and I'm paraphrasing what one of the reviewers said, but she reviewed every single public award on the subject or ruling on the subject of fair and equitable treatment. Finally, also here in the room, we have Bianca McDonnell, a senior associate at White & Case, who is now based in New York. Bianca was my student 9 years ago, which makes me feel incredibly old. But even then, she was such an impressive advocate, just in doing the exercises that we did in the advocacy class. And then I heard her say something that later stuck with me because what she did afterwards was so impressive. So at the time, Bianca spoke English and French. And I heard her say in French, "Oh, I don't speak Spanish." And she subsequently went off and became professionally fluent in Spanish, now works in Spanish, was a tribunal assistant or an assistant to an arbitrator for a long time in Madrid, then shifted over to White & Case, first in Madrid, now in New York, where her practice is based on commercial arbitration, investment arbitration, and some construction arbitration. So wonderful panel here to talk about how we all talk to each other, how we will work together in the future. And to get that started, let me ask the panelists how you answered the first 2 questions. Bianca, I'll start with you. Tell us where you're from and what languages you speak.
So I was born in Sydney and I grew up, born and grew up in Sydney, Australia. And I speak Aussie, which is its own language, if you are familiar with it, Spanish, French, international law, which also has its own way of speaking, common law, Gen Z, and arbitration Latin.
That's a good one. Kendra, what about you?
Well, it won't come as a surprise after Mallory's introduction that I grew up with Mallory. Upside down. Yes, from the Washington, D.C. area, so the capital of lawyers. And I speak probably also international law, should have been on here, but English, Spanish, French, sports, and Portuñol is what I chose to write down.
Mairée.
Hi, and thank you for that wonderful introduction. And I'm sad not to be able to be there with you all, but very grateful to Mallory and to Jose Antonio and to everyone to be able to join you at least virtually. So I also followed the instructions and prepared a little board that I don't know if you're able to read.
By the way, I told Mairée that she could just, write it on a piece of paper. So thank you, Mairée, for embracing it.
Can you read it? So I first had a question as to when we stopped growing. Like, what is it? Which were the places that we had to pick? But I was born in Colombia, moved a few years later to the US, a couple of years later to Spain, and then went to law school in France.
And what
as
languages
to
do you
the
speak?
languages, sorry, I was forgetting the second question. So I speak English, Spanish, since I'm Colombian based in Chile, French, public international law, climate change and environmental law, civil law principles, and common law principles.
Gaela.
I grew up in very rural Illinois in the United States. And some of the languages I speak are Spanish, English, French. I try. I
I'm introductory Gen Z because one of my kids is a 13-year-old. Music, Italian, Portuguese, common law, basic, meme, again, the 13-year-old, and Mexican.
So having heard the languages that everyone else shared, does anyone want to supplement their language submissions? I'm going to give you the option to do it anyway, because I think these are some of the ways that we actually manage to connect in the field. You know, we have the lingua franca, because I also speak a bit of arbitration Latin, knew that there would be someone in the room who would judge me for not using the plural. So we have those lingua franca, we have English and French and Spanish and German and all of these other languages, the Latin, but it's things like speaking civil law, speaking common law, speaking damages, speaking millennial, Gen X, Gen Z, that truly enable us to work with each other and to persuade our colleagues. So please feel free to keep adding to the list. It'll be interesting to see what comes up. Ooh, economics. Sign language. Meme, glad to see that one up there too. No one has emoji, which is also, you know, they're different dialects based on the different generations. I feel like there's ironic emoji and then unironic emoji, regular emoji. So now that we have a little bit of a sense of where people are from, what languages we speak, I want to hear about how we all came to this practice area. So the next question or set of questions is going to be about when you first learned of international arbitration. First of all, tell us what year it was. Some recent additions. Okay, and how old were you? Roughly, you know, this is anonymous, by the way. I have no way of checking. So while everyone is continuing, let's turn to the panelists. And this time we'll start with Gaela. Gaela, when did you first learn about international arbitration? Give us the year, your age if you want to or don't want to, and just tell us the story, the circumstances.
Right. So 1994 was my second year of law school, and I was around 23 years old. So at that time, I think much unlike what Georgetown Law offers now, which is a whole host of law school courses on just international arbitration and different types of international arbitration. At that time, Georgetown offered 2 classes in international law. International law 1 and international law 2. And I remember, you know, that was something that I was very, very interested in and took international law 1, my second year of law school. And that is where I first heard about international arbitration. And I don't know if I can remember the actual cases. We actually discussed within international law 1 a few commercial, what I now know as commercial international arbitration. Investment arbitration didn't quite exist yet. I mean, the treaties were being signed at the time. So yeah, I heard of and studied commercial arbitration cases.
Mairée.
So to be honest, I don't remember exactly the first time I heard about it, but the first time I consciously started finding out about arbitration was when I was doing my master's degree at the Sorbonne in International Economic Law. And I was trying to find out, I was trying to find a topic for my master thesis. I had to write a small thesis, and I had no idea what I was going to do. And my mom was visiting, we were in Paris. My mom was visiting, and I have no idea why. She found a newspaper, I imagine Le Monde or something like that, that was reporting on the work on dispute resolution and the work that the ICC was doing in connection with Latin America. And she's a historian. She has nothing to do with the law. And I don't know why she found this interesting and told me, well, why don't you write your thesis about this? Because she saw that I was a little bit lost about what I was going to write about. And so this is how it all started. I later, through some contacts, contacted Eduardo Silva Romero, who at the time was the Deputy Secretary General of the ICC, and then wrote my thesis on transnational, what I call transnational arbitration relating to Latin America. And that was what my thesis was on. And I was about 23, 24 years old. And that's where it all began.
Very cool. Kendra?
I hope everyone can hear me because I realized I made a mistake here and sat away from the microphone. Boomer mistake. So the answer is I don't know. As Mallory mentioned in her kind introduction, I am a second-generation international arbitration practitioner, and I am the byproduct of two international lawyers, much to my great fortune, one of whom is online, I can see him, and he was involved in the negotiation of the NAFTA, and the other, who I'm going to put on the spot, and it's in this room, Lucinda Lowe, who in my very humble and biased opinion, is an excellent arbitrator. So there was a dinner.
And was on the last panel.
And was on the last panel. So that was a dinner topic conversation every night. So I really couldn't place when I first heard of it. I was probably in my teens. I do remember when I became super interested in it for myself, which was during my master's studies in 2010 in Geneva. But yeah, it grew up with me, I would say.
I would have probably heard the term arbitration, I guess, in my law degree, but similar to Gaela, it was more recent than her, but in Australia, it is quite domestic, especially when I studied, which was, I graduated in 2015. So at the time at my university, international arbitration or international law generally was not offered was not compulsory. I don't think it was even offered. International law probably you could possibly do. So I had never really heard about it or focused on it. I really discovered investment arbitration and international arbitration generally when I was in the UN, doing an internship with the UN in the ICTY, at the ICTY in The Hague. I had recently gotten very interested in international law, but specifically international criminal law and humanitarian law. So I went to do the internship. I had signed up for my LLM at Georgetown, and I was in the process of choosing my subjects, and I discovered this really cool sounding thing called investment arbitration, where you can both be a lawyer and work at a law firm, do advocacy and go to hearings, and also practice international law. And at the time, doing an internship at the UN, realizing that it's difficult to work actually in international criminal law, this sounded like an amazing sort of in-between that would be cool to specialize in. And so I selected it in that way, and then I was lucky enough to start working in it after I graduated, and it's been wonderful.
So you didn't ask, but I'm going to tell you anyway. I am basically in the middle of everyone. When I was in law school at my university, they didn't really have many international law courses on offer. They had some, and there was an ADR class, but they weren't put together. So I first heard of international arbitration when I was doing a mock interview with Gaela. It was either right before I walked into her office, an associate mentioned to me what they do, or Gaela told me during the mock interview what they do. But I went through law school just hoping to be able to do something international, and had all of these internships, and then needed to pay for law school. It's expensive in the US. And so I was working at a golf course, and one of the members happened to mention to me, he knew I spoke Spanish, and said, oh, we have this wonderful team that does a lot of work in Latin America that just joined. would you want to come in and meet them and do a mock interview with us? And I just found the field so fascinating, to get to argue about fairness every day. To me, that's the essence of law. And I thought this was amazing. So I kept pushing until I turned the mock interview into a real interview, and then got to stay in the practice ever since. And since that time, there has been a lot that has changed. And that's what I want to explore next. I realize that this is a tricky question to answer succinctly, but we're going to try it anyway. Tell us, first, the audience, what has changed since you first joined the field? Whenever it was. I would recommend being generic with this. We will ask the panelists to be very, very specific in their answers, but just tell us about some of the things that have changed. And just one example. Feel like we should explore the my interest one later on. Perhaps during the reception. And again, no one asked me to comment, but since I'm asking the questions, I can ask myself. Some of the things that jump out at me are the fashion, the people, the way that we research, the way that we communicate, the technology that we use, the sheer number of cases that we have, the amount of research you have to do in every single case that you're working on. It's expanded as we've gotten more and more jurisprudence in this area. Let's start with Kendra this time. Can you share some examples of either little things that have changed since you were, born and learned of the field, or moments where you realized that something might be changing? Like, what are the symbols of change or the moments of change?
Sure, absolutely. So
Sorry, I can't hear Kendra.
that's fine. Okay. Sorry, can you hear me now?
Yes, sorry, thank you.
So I'll just try to paraphrase that. Growing up in DC, I think at the time, and maybe people who are still based here can chime in on this, I would consider it to have been a kind of conservative legal field. So women had to wear closed-toed shoes and wear a suit and no nails painted. Pantyhose. And then I moved to Europe and got involved in more international organizations where women could wear more colorful clothing or paint their nails. And that was a big surprise coming from, I think, this jurisdiction. In terms of the change I've seen over the course of my career, and I think this will be a no-brainer for everyone, is just technology. And COVID specifically was a big moment where a lot of things shifted. And I know a lot of people here involved in international investment arbitration, so I'll try to take the side of sports arbitration because that's a whole different world. Coming from ICSID to CAS, there were things that I was really surprised to see in practice there. For example, they had a folder that would go around gathering physically signatures on letters to go out. And that was in 2018, so fairly recent. And then during the time there, I would venture to say, because I started doing it, was using electronic signatures. That was already quite revolutionary for that institution. And then COVID really shifted towards, virtual hearings, e-filing, and that happened across institutions, but CAS was particularly conservative compared to somewhere where ICSID, which almost immediately went to electronic filing as a default. It took a long time for CAS to get there, but it wouldn't have happened but for COVID. So in general, I think just more electronic means of communication, filing, et cetera.
And you reminded me that I forgot to mention one of the coolest things that you have told me recently, which is Kendra is now on the list of arbitrators for an esports dispute resolution board system. which is not something that I would have thought of or that we would have seen 10 years ago, 15 years ago. So things are changing. Mairée.
Thank you. So some of the things were kind of already mentioned by Kendra. I think the first thing that came to mind was e-filing. And indeed, I mean, I think yes, it's true. Except when the pandemic happened, moved very quickly to e-filing and to virtual hearings. The move had started a while before internally, and it took a lot of push and a lot of conversations internally to get there. And it was, I remember, always having to be worried about whether the arbitrators were getting their copies, and arbitrators asking for A5 copies and those little booklets with all the pleadings. And while I'm sure, I mean, that still happens, and in the cases I'm sitting, there are a few arbitrators that still request those booklets. Most people are now moving to electronic filing. So I think that's a major change, and one, of course, that it's welcome for environmental and climate change concerns. The other changes that I would mention, and that were also mentioned by some members of the audience, was, of course, diversity. I think that while we are not there yet, we are seeing younger people sitting in cases as arbitrators. We're also seeing a bigger pool. I'm not sure that it has actually that the pool, that the regional diversity has actually grown as much as the gender diversity. And even if the gender diversity still has a long way to go, but I think we are, the field is changing a bit. And then ISDS reform also, I think it's a big change, in the sense that when I joined the film, it was this very exciting new field of international law, but that was in the intersection between public and private law. And it was many times conveyed as a means to help bring investments to countries where it was needed. Today, it is a lot harder to hear that same story, and instead we hear, of course, of the backlash. So a lot of uncertainty as to what is going to happen with ISDS. And my final point, which goes a little bit more to the substance, is that I do see a growing push for arbitral tribunals to be more, to lead with more firmly the process. And I think the change is not universally, and it doesn't happen in every case. But I see more and more counsel encouraging arbitrators to take a more proactive role and start making the difficult procedural calls or the difficult procedural decisions, and not simply endorsing all the procedural suggestions that come from the parties out of fear of overstepping or of infringing due process. So those were the changes that I wanted to mention.
Thank you, Mairée. And so I don't know if I've mentioned this to you, but one little moment that stands out to me as a change is when, for many years, you had used a hyphen between your last names. And there was a moment when you said, no, I'm going to actually write my last names as I should write my last names, as I want to write my last names, and removed the hyphen. And that there also was a moment, Gaela, when I started seeing people actually saying Gehring Flores, in understanding of the last name conventions. And to me, that was just a big moment, that people were actually respecting and understanding the history, the reason why last names are set out in that way. And it showed that we definitely aren't all the way there when it comes to diversity, but we are making smaller steps and getting closer. And some of these little baby steps are things like getting people's names right, pronouncing them correctly, understanding how everything is spelled, what's capitalized, hyphenated, not hyphenated, etc. So little changes that can have a big impact. But Gaela, tell us what you think has changed.
Thanks, Mallory. I mean, and as perhaps the oldest member of the panel here, and I think Mallory can vouch for me that even though I'm the older one here, I am pretty much an early adopter of change, and very accepting of change. That said, the fifth memorial, I'm still working on that one. I'm not a fan. You know, I started in the international arbitration practice in the 90s, and I look at the convention and I look at the rules and it says, these are the memorials. That's it. You know, you don't know. Claimants do not get the last bite of the apple. Okay, but I will not vent all day, but that's certainly a change. That's happened relatively recently. That's happened, and this is an investment arbitration. That's happened maybe over the past 6 years, 7 years. Also for me, since I started in the 90s, just using email to actually file official filings, that definitely didn't start that way. The idea that you would send a tribunal an email, that would just have been crazy. WhatsApp. I mean, WhatsApp is king with clients. The idea that you would just be WhatsApping your clients all the time, or Signal, as it may be. I remember back in the day with Kelby Belena, who's here. Mad dashes to ICSID with boxes and boxes and boxes of physical documents, because we had to turn them in person and have them go through the metal detectors. And so that has certainly changed. Just the existence of ISLG and Jus Mundi, you know, having those sorts of databases, that's quite a big deal. Cell phones. I mean, I remember getting my first cell phone at work in the 90s. That was quite a change. Laptops, like actually being able to take your computer home and not having it be fixed to your desk at work. And actually, you know, not just cell phones, but then being able to work on your cell phone. You know, being able to work on a document on your cell phone, crazy. And the ICSID rules, you know, during my time have changed at least a couple of times. So lots of changes.
Bianca.
As I'm more of a younger practitioner, but with about 8 years of experience so far, my changes that I've seen are obviously different to the other panelists, but still in my time, I've seen changes. I think Signal and WhatsApp is definitely one that I've seen. One of our clients, you're more likely to get a response from him via Signal than via email. AI, of course, that's a massive change that we're all living through. And we're still seeing how that is impacting the practice. And we still have, I think, a long way to go and a lot of evolution. But we have one client that sends us AI generated briefs that he wants us to incorporate into the brief, send to the damages experts in very complex investment arbitration cases, that he thinks that AI can, you know, do the job of, or come up with ideas that he wants us to take into consideration. And of course it can. It has a long way to go in order to be able to, you know, replace an expert quantum report. But it's definitely a shift in what the clients want from us, as in they want us, I think, to be relying on and using AI in order to make us more efficient and things like that. As has been said, but diversity, and specifically, I've seen younger female arbitrators be appointed. So my friends who I was working with when I started my career at with Juan Fernandez Armesto, my colleagues there that were also secretaries of the tribunal like me, are now ICSID arbitrators. They are chairing ICC cases and annulment proceedings. So that is I know that, of course, women were appointed previously, and some young women as well, but these women are quite young. They're a couple of years older than me. So that's awesome to see that the arbitral practice is starting to give more opportunities to younger women, and or younger people generally, because I think it also applies to men. I think men, especially in more regional arbitration cities, are seeing more appointments, which is a great shift. And document production, I think, is one where the type of documents we can ask for is evolving as the concept of creating a document evolves with technology. So WhatsApp conversations, I haven't asked for it, but I think we could potentially ask for a ChatGPT conversation, because essentially you are creating a document by the correspondence that you are having and the conversation you're having with ChatGPT. That would be dangerous, but potentially could be requested. So, yeah.
Well, and also the way that you formulate document production requests has changed or is going to continue changing. The first time I asked for production of social media posts from someone, I had to explain to the arbitrators how this particular form of social media worked. And as social media continues to evolve, we'll see those changes. Maybe the younger arbitrators will know how TikTok works and how you can request TikTok posts or exchanges of messages, whatever it is. Maybe they won't, as there's some new technology emerging. But in any case, change is very much a constant in our lives in international arbitration. So I want to take everything that we have discussed so far about how we came into this field, the changes we've seen, our different generations, and put it together. For this part, I would ask, though, that you put your cell phones to the side, because even though technology is wonderful, it can't always do everything. And for this part, we're going to go with an analog option. So to everyone who is here in the room, I would ask that you take out those little packets that you got earlier. And as you will see inside, there is a pocket that has cards inside it, and those cards are color-coded to the different generations. So please either select the color that corresponds to your generation, which you will see on the screen, or if you don't want to share or reveal your generation, or if somehow your generation is not covered, we also have a wild card in there for you to use. And so there is a camera in here so that the people who are participating over Zoom can generally see how everyone is voting. So to make sure it works, everyone just please hold your card up in the air, hold it high so everyone can see. Working. Very interesting. So lots of millennials in the room, but still a pretty good mix. Okay, so we're going to do a rapid fire round of questions to see what the differences are in the various generations. We're going to go through lots of different topics, and then at the end, we will have the panelists comment. So please raise your hand. We're going to start with some mentoring training style questions. Raise your hand if you have or at any point have had a mentor. Raise your hand if the mentor was more senior than you. Raise your hand if you have ever learned anything meaningful, a lesson or a skill, professional lesson or skill from someone more junior than you. All of us, right? Okay, raise your hand if you're an attorney. And keep your hand up if you studied international arbitration in school. Yeah, let's say law school. Okay, and raise your hand if at the time when you obtained your law degree, let's say first law degree, because there are a lot of overachievers in the room, Kendra. Raise your hand if at the time when you obtained your first law degree, specialized courses in international arbitration were common. Interesting. Raise your hand if your first job in the legal field was in the world of international arbitration. Raise your hand if you first spent time in a different practice area before shifting over to international arbitration. And raise your hand if you currently handle international arbitration work almost exclusively. So you do that basically full time. Okay, turning to technology. Raise your hand if you've ever used a typewriter. Okay, raise your hand if you've done it unironically, like you've, okay. So keep your hand up if you have used a typewriter for work. Okay. How about physically cutting text out of one document and pasting it into another? Raise your hand if you know what whiteout is. Have you used whiteout professionally? More than I thought. Okay, raise your hand if you've ever used a dictaphone. Raise your hand if you know what a telex is. It's mentioned in the UNCITRAL rules, I think. Raise your hand if you had a professional fax number. And keep it in the air if anyone ever sent you a fax at that number. Also impressive. Raise your hand if you had a dial-in number. A BlackBerry for work. Some hands went down. Raise your hand if, this is one of my favorites, if you know how to dial an international number from a landline. Isn't it nice that we don't have to go through that adventure anymore? Raise your hand if your first email address was a professional one. You. If your first email address was one that you were assigned when you attended university. Few more. And if your first email address was a professional one, or sorry, a personal one. Majority. Communication. Raise your hand if you regularly speak with your colleagues in person. How about if you regularly speak with them on the telephone? Via email? Through a chat app that is installed on your desktop? Through a chat app that is installed on your phone? Raise your hand if you regularly call your colleagues without scheduling the call in advance. Keep your hand up if they answer. That's pretty good. Raise your hand if you either keep a headset on or earbuds in for the majority of your workday. Raise your hand if you've ever included an exclamation point in an email that you've sent from your work account. See, okay, basically everyone, almost everyone, my husband is not raising his hand, but the majority of people are raising their hands. Even senior members of the field use exclamation points. Raise your hand if you've ever sent an emoji to someone else in the field. A meme, maybe. Raise your hand if you include a period at the end of every single text message. Generational divide there. Raise your hand if you rarely capitalize words in your text messages. Also generational divide. And if you routinely text other people in all caps. Okay, good, glad. So for those on Zoom, no one answered their hand for that one. Work culture and habits. Raise your hand if you've ever pulled an all-nighter. Almost everyone in the room. Raise your hand if you've ever had a colleague handle the clicking for you in PowerPoint. More than I thought. Come on, millennials. Raise your hand if you've ever used a reference or analogy or turn of phrase at work that had made you feel young. And what about a reference, analogy, turn of phrase that made you feel old at work? Starting to happen, millennials. Okay, and then I promised this one on LinkedIn. So we're doing a little bit of Know Your Meme Arbitration edition. Again, we are in DC, so it is largely investment arbitration focused. But raise your hand if you know the phrase Liber Amicorum. That one isn't going to the juniors. So there are these really cool books that people would write for you in your honor once you reached a particular stage in the field, and everyone would write an article, submit it, and then you had, it's a friendship book for you in honor of your achievements in the field, which I always thought was super cool. But I know that because when I started out, we actually went and did our research in a library. You know, we didn't have ISLG or USMUNDI yet. Speaking of, raise your hand if you were already working when ISLG was launched. Raise your hand if you were already working when USMUNDI was launched. Raise your hand if you were involved in one of the Argentina cases. I'm glad to hear the laughter because sometimes I'm not sure that everyone remembers what the Argentina cases were. So raise your hand if you know what the Argentina cases were. Okay. Raise your hand if you have been involved in a solar case. Or raise your hand if you have heard of those cases. And finally, raise your hand if seeing the phrase "Ixid AF" makes you giggle. Not as many as I thought. So personally, I thought that was fascinating to see from my vantage point, all of the different generations. We have a lot more in common than I thought we would, which is really nice to see. But again, you're not here to listen to me speak. I want to turn to the panelists. Who hasn't gone first yet? Bianca, have you gone first? Mairée, you haven't gone first yet. Over to you. Tell us any reflections that you have and sort of what you think about all of this going into the future. Any thoughts, advice, words of wisdom for us?
I think for the younger generation, perhaps just a small advice is if you are interested in ISDS, I would suggest that you work across different areas of public international law and not go directly into investment arbitration, or don't focus only on arbitration. Because I think the broader your perspective, probably the more effective you will manage to be in the field, and this not only now, but also going forward, because I think we are going to start seeing a bigger integration of principles of, or I hope we'll start seeing a bigger integration of principles of other fields of international law into ISDS, and that's part of what I'm seeing. And perhaps a second advice would be to be bold and reach out to people who are doing the kind of work that you want to do. And I'll just give you a very quick example. Yes, very recently, somebody found me through LinkedIn, contacted me. Fast forward, we ended up having a WhatsApp conversation. She was looking for career advice, and it turned out that she actually had experience in international environmental law, is focusing her PhD thesis on that, and probably is going to become a research assistant on, a NASAL task force that I'm co-chairing about ISDS and climate change. And so this was just a message out of nowhere that she sent me that ended up being what I think will be a good opportunity for her. So just be bold and on the lookout as to what you want to do.
Great advice. Gaela.
I think by now many of you know that I would think I would be very remiss not mentioning the current situation that we face and the current state of our world and the current state of the rule of law, which is facing quite a significant attack, if not destruction right now. And so I think given what we've learned today, the differences and the commonalities in the generation, if there's one thing that is most important, is that we bring all of the experience between all of the generations to defend the rule of law and to stop its destruction, and to remember that in fact, the field of international arbitration was created to minimize, if not eliminate, violence as the tool to resolve disputes. And if we watch the rule of law be destroyed, what's going to happen to our profession? If there is no rule of law, there is no use for lawyers. So it is, in fact, necessary for all of us to do our duty, to actually look again at all of the oaths that we swore to the rule of law, and do it, defend it, before it's too late.
Kendra, tough act to follow.
Well, I can only second what Gaela just said very beautifully. And I'll build off it in a slightly different direction, which is to say the importance of connections and networking and attending events like this where people can exchange ideas and talk to other lawyers and find our commonalities more than our differences. So I think that's super important in maintaining the profession and reaffirming these principles of rule of law, et cetera. Stepping back a little bit from that heavy topic, if we want to say that, to second again what Mairée also kind of touched upon, I think it's very important to familiarize yourself with many times the dispute settlement, not just international law, but also dispute settlement. I mean, I started in the commercial arbitration field. I then went to investment and then to sports, and they're very different worlds. Commercial and investment are more similar than sports, of course, but you can learn a lot from other dispute settlement mechanisms or approaches. And I saw a lot of colleagues in the sports arbitration world who didn't know, for example, what a procedural order was. And so to not have that kind of basic knowledge of arbitration was kind of a shock, to be frank. So I think it's important to familiarize yourself with as much as you can with different procedures. It can only enhance your practice and your knowledge. And then, yeah, I guess as well to touch on what Bianca said earlier about emerging technology, it will go back to what I said about the importance of in-person appearances and connections. And I think that will translate into the arbitration field. I don't know if anybody else has thoughts on that, but I can see virtual hearings becoming less prevalent than they have been in the last 5 years and returning to in-person hearings to ensure that there's no fraud or, some kind of interference with testimony, et cetera, et cetera. So that's just one thought I had when thinking about the changes we've seen and how it might change.
Bianca.
Yeah, I agree definitely with what Kendra said, that I think we're going to see big changes in the future to how we practice in terms of technology. And I think the use of AI it increases the importance of oral advocacy skills and cross-examination skills, because they are the things that a robot or an AI tool can't replace. So I think, especially for the younger generations, of course, writing is important, and don't think that you shouldn't hone in on your writing skills, but I think it will set people apart, the ones that are good advocates ultimately, because everyone, will need more of that as opposed to the drafting in the long future. I don't know how long, but at some point in the future. So strong oral advocacy. Also, I think we may see a shift in how arbitrators give their awards. So instead of written awards, we may see oral awards be given for the parties to be sure that it truly is the arbitrator making that decision. So that could be a shift that we see in the future. The other thing I think is changing with millennials, but younger millennials, and specifically Gen Z, and I do believe that in the long-term future there will be a shift to the way we practice, is work-life balance. There is a massive generational tension between how the older generations have done things previously and what the younger generations are willing to do, or just how much they're willing to commit to the practice in the same way that the older generations have. Not to say that the younger generations don't want to do a good job and work hard, it's just that there is definitely a shift that I've seen, and that I feel the pull on both sides. And I think Gen Zs are even more focused on work-life balance, what suits them, being aligned with the firm, with the company, even more than millennials. And so as they join the practice, which they are now, there's going to be more tension there. And I think both generations on all sides need to understand each other, work together to sort of bridge that gap and find flexibility, so that the younger generation can also want to be in the workplace, so you can keep them around. So I think that is a shift, especially after COVID and working remotely. So that's something that I think will definitely change in the future.
So we didn't plan this, but that works out very well, because one of the things I was going to mention is, not just the tension of being pulled in different directions, but the crunch on the generation in the middle when you are sandwiched in between these generations that have different expectations and different goals and different cultures. It can be really, really tough. And my piece of advice for everyone going forward would be just to continue having these conversations, to talk about the little things, to engage with each other in person where you can, or using our many other forms of technology that we have available to us, because we do so much work in our heads, and getting outside of our own brains is the way that we all grow. It's the way that we improve our work, by doing these things as a team, by testing arguments internally before they go to the decision maker. So talk to your colleagues, engage with your colleagues, ask questions of each other instead of just making assumptions, which can be really, really hard to do when your entire job is predicated on making those judgment calls. Forcing yourself to get outside of that and ask, could I see this differently? Is someone else seeing it from that other perspective? Just talk about these things, ask questions. And so on that note, one last question for everyone. Who's ready for the reception? I take that to mean that most of us are, and we ended almost basically on time, considering that we started late. We picked up some time in the air, I would say, if I were a pilot. So I just want to thank all of you for coming out, thank the WOW team and BakerBots for hosting, and especially thank our fantastic panelists for this really, really great discussion. Thank you all.